The Constitutional Court has dismissed with costs the application by Correctional Services for leave to appeal against the Supreme Court of Appeal ruling that's regarding former President Jacob Zuma's medical parole. South Africa has been experiencing sub-zero temperatures and snowfall across the country. And South Africa's double Olympic 800 meters gold medalist Caster Semenya has won a crucial legal battle in her fight to compete without taking drugs to lower her testosterone levels. A very good afternoon. If you've just joined us, we're coming to you live from our studios in Johannesburg. Welcome to Week in Review. That's the program where we review some of the biggest stories to come out of the week. I'm your host, Mfundo Babalan. We start here. The Jacob Zuma Foundation has confirmed that the former president is receiving medical treatment in Russia, but it declined to give more details or say when he would be returning to South Africa. Confirmation that the former president, Jacob Zuma, is in Russia came after Thursday's Constitutional Court ruling on his release from jail. The Con Court upheld the Supreme Court of Appeal's ruling that Zuma's release on medical parole was unlawful.
We regard this as a major victory for the principle of equality before the law, where the law must apply to everybody, regardless of whether they're a former president or an ordinary citizen of the country. Additionally, we welcome this judgment because finally we hope it's going to shut off the avenue of the abuse of medical parole by well-connected ANC individuals to avoid the outcomes of their criminal misdeeds.
The Freedom Front Plus has warned from the start that we should not have a repeat of a shabby sheikh situation when it comes to Zuma. We have said that he must serve his sentence, and the finding of the Constitutional Court is not final. He can still go to the Constitutional Court for a final decision. But the Freedom Front Plus has said that he should go back to jail, and we must stop wasting taxpayers' money on legal costs.
The ACDP believes that this long-running case has certainly tested South Africa's constitutional order. We support the decision of the Constitutional Court and again adhere to the rule that every South African citizen must be seen to be equal before the law.
All right, now still on our courts, the Constitutional Court has found that justification for the precautionary suspension of Busio Mkhwebane existed and that the president's decision was found to be rational. SABC News reporter Kenny Mapanga filed this report.
Another blow for suspended public protector Advocate Busisiwe Mkhwebane as the Apex Court upheld her suspension. The Constitutional Court ordered that the DA and the President's appeal applications against the High Court order are upheld.
The President did not suspend the public protector to prejudice her. The suspension is only a precautionary one and does no harm to her, as she remains on full pay, has time to properly attend to her defense in the Section 194 inquiry, and suffers no reputational harm, as she is already subject to a highly public inquiry in which the allegations leading to her suspension have been ventilated.
The judgment comes amid a Section 194 probe into Mkhwebane's fitness to hold office and her term coming to an end in October. The presidency has since welcomed the Concord judgment.
President Ramaphosa has noted and welcomed the Constitutional Court decision on the suspension of Advocate Busisiwe Mkhwebane. The Constitutional Court judgment affirms the fact that the President acted within the rule of law, and it also affirms the President's adherence to due process and fairness. As you'll all know, the suspension followed the decision by the National Assembly to institute a Section 194 process against Advocate Mkhwebane.
Meanwhile, the Democratic Alliance, which launched the application, says that the Constitutional Court decision was the correct one.
I think it is just another indication of how unsuitable she is to be the public protector, and I think it is just another indication how we need this Section 194 process to conclude as quickly as possible so we can close this chapter on this terrible public protector and start the new chapter of finding a new public protector.
The EFF, however, disagrees with the finding of the court.
Well, we disagree with that, and it is well within the rights of the EFF to disagree with the court. We respect the decision of the court, but we don't agree with it.
Kani Mapanga, SABC News, Johannesburg.
All right, now joining us for more on these two big legal stories is Advocate Ntuiseni Ralikubane. He's the member of the Johannesburg Society of Advocates. Advocate, good afternoon and thank you very much for your time. Let's perhaps start with the former President Jacob Zuma matter. Now on that one, the SCA judgment is the final judgment. Let's zero in on that judgment just to settle this debate around whether the former president should report to prison immediately or not. If we look at paragraph 60 of that judgment, it states the effect of setting aside of this declaratory is that once the order of this appeal is handed down, Mr. Zuma's position as it was prior to his release on medical parole will be reinstated. It then goes on further to say, in other words, Mr. Zuma in law has not finished serving his sentence. He must return to the Escort Correctional Center to do so. That is part of paragraph 60. What is your interpretation of that?
Thank you. Afternoon, and thank you for having me. My interpretation of the judgment is a simple one, and it is that Mr. Zuma, subsequent to his failed attempts to appeal against that judgment at the Constitutional Court, must return to the Correctional Services Facility with immediate effect. And we know that there is an impediment to that as it stands because we understand that he is ill, but at the end of the day, the judgment, or in terms of the judgment, he must return to the Correctional Service Center.
So that settles the debate that indeed he does need to be at the Correctional Center to be in the position that he was in before a decision on his medical parole was taken. Am I correct?
That is so much correct. He must be restored to that position and continue to serve his sentence. If at all he needs to exercise other rights, what must happen first is that he must return. All else may have to follow after that.
Now, still on that paragraph 60 of the SCA's judgment, I'll paraphrase and just not quote it verbatim there. It basically states that the court will not interfere in the decision-making process now of the correctional services, that at the very least, they will be the ones to determine if the time spent outside was in fact sufficient and he no longer has to serve time. Just talk to us about that process now. What process would they have to embark upon?
Yes, seeing that the court refused to entertain or enter the fray in so far as the administrative decision is concerned, it simply means that the commissioner or the Correctional Services Authority must or may consider, say for example, if Mr. Zuma requests that the time he spent outside should be considered in the 15-month period which he had received at the time he was sentenced, then that request can be done to the authorities. If they accept it, that will be fine. The other point is he may have to ask for a parole, maybe on a different ground. We know that he was released on the basis of medical parole. There are many other types of parole he may have to ask for. Say, for example, he may have to ask that because he served 2 months of his sentence, then he can be considered for a normal parole. Those are some of the things that he may consider, but once he is back in prison.
You touch on the commissioner, and I know that there's a different dynamic now when it comes to the commissioner, because we remember that AfriForum was granted that declaratory order stating that the Medical Parole Advisory Board is the one that going forward would take the final decision. So meaning the powers of a commissioner have been limited. So what does this actually mean?
That is correct. Insofar as the medical parole is concerned, in fact, parole in general, the commissioner cannot consider the application for a parole, make a decision all by himself without the recommendations of the parole board. It simply means that he must understand that even though he has been given or he has got the powers or the court refused to entertain that part and leave it in his hands, he must understand that he's being watched. If at all he has to consider any application or request by Mr. Zuma, he must do that within the bounds of the law. If he doesn't do that, he can be challenged again.
Mm-hmm. Now, in terms of what we've been monitoring on social media, political solution and presidential pardon are some of the terms being bandied about right now. Can he actually apply for a presidential pardon prior to reporting to Escort Correctional Facility?
In my view, it will not be prudent or appropriate to ask for a presidential pardon before he goes back. My view is that he must go back. Once he is inside, then he can exercise any other existing right that he may have.
Mm-hmm. But what is the likelihood of him being granted a presidential pardon? Perhaps if you could outline the criteria thereof.
The chances are there that he may be granted a presidential pardon, which means that when he is in there and he files that request and it's coming at the right time, you may have heard the other political organizations talking about prisoners of a certain age who must be pardoned and all that, or must be released. So it's happening at the right time. Maybe if the president considers or decides to consider that, he can be part of those who will be pardoned and released, but he must make a request to be released. If he doesn't make that request, he may not benefit from that.
Mm-hmm. You know, this particular case has had political implications as well as legal, as we've seen. I just want to take you back to Judge Matojana when he first was seized with this matter. You'd remember that he in particular had sort of replaced the decision by the DCS, by Correctional Service, with his own. And then we saw the SCA took it back to DCS to say, now you will take a decision. But when we look at the time just after the judgment, and then after him granting leave to appeal, Judge Matojana, there was a bit of difficulty where we saw that it seemed he was being bullied in certain quarters as a judicial officer. I just want to talk about, as legal practitioners, is there a concern around right now the attack on the judiciary ever so often, where it seems a bit difficult to execute their duties? Because I remember quite vividly that the second time around, when Judge Matojana was granting leave to appeal, he spoke of the need to consider the former president's age. You know, the tone was somewhat of a person that had been dealing with a lot of trauma post the previous decision, where there were a lot of attacks. What is your view as a legal practitioner on just what we're seeing insofar as the judiciary is concerned?
Indeed, it is unfortunate that the judiciary is under attack constantly, most importantly by politicians. And I must say, in many instances, those attacks are ill-founded. You will find that a particular politician is attacking the judiciary because he is not happy with a decision of the court. Now, it would be prudent rather to say, well, there is a decision of the court which I am not happy with. I would get an opinion or a legal opinion to see if I cannot challenge that. We see other political organizations challenging the decisions of the lower court up to the highest court of the land. That is the right way of doing things. But to go out there and criticize the courts for the decisions because you're not happy or they're not happy with the decisions of the court, it is very unfortunate. And unfortunately, that is what is happening right now.
And I'm glad you state that there are avenues, because we saw what happened with Judge Matojana's orders. Those two were in fact set aside by the SCA to say, no, we will not take a decision for the DCS. We will give it back to them to decide on the term he has served or not served. So meaning there's always a remedy as opposed to attacking. I want to take you to another big story of the week. That's the one of the suspended public protector, Busiwe Mkhwebane. What are your views on that Constitutional Court outcome? Did you expect it?
Indeed, I did expect that. If you look at the approach that the public protector or the suspended public protector took, it was based on the fact that the decision of the president at the time to suspend her was not rational. But if you look at the fact that the Constitution empowered the president in terms of Section 194(3) to suspend the suspended public protector immediately after the National Assembly starts with the process of the impeachment. So the president acted within the bounds of the law. And yes, we expected this decision.
But a lot of legal scholars went to town telling us about just that aspect of reasonable apprehension of bias, that it doesn't need to be bias that is evident for everybody, but just that reasonable apprehension. What did you make when just monitoring that sort of debate?
There are two issues which I can raise, and they are of great significance. One is the principle of natural justice, which is referred to as nemo iudex in sua causa, which means no one should be a judge in her or his own case. Now, the argument that the president suspended the public protector or the suspended public protector when he realized that she was investigating him is, while we accept that it was not or it is not strong, but one can accept that maybe it is debatable. Maybe she has a point. Maybe the president ought not to have suspended her, seeing that she had already started investigating him. But someone may argue that, well, the president did not suspend the office, but an individual, and the suspension of an individual from office did not mean that investigations should then immediately come to an end. We would remember or recall that investigations continued, but in the absence of the suspended public protector. My point is, it is an issue that is debatable.
Advocate, thank you very much for your insights this afternoon. That was Advocate Ntuwiseni Rali Kubana speaking to us. Let's look at this story now. A court-ordered psychiatric report has found that Zandile Mafe, the alleged parliament arsonist, is unable to follow court proceedings and therefore unable to make a proper defense. It's also found that at the time of the alleged offense, Mafe was unable to appreciate the wrongfulness of the act. Western Cape High Court Judge Nathan Erasmus lifted the ban of the report's findings, but did not disclose Mafe's medical condition. Mafe has recently undergone a period of psychiatric observation at Fort England Hospital in the Eastern Cape.
Zandile Mafe entered the dock making a number of utterances, including that he burnt Parliament and would do it again.
It must relocate, it must move here, this Parliament. I buried intentionally, me, Christmas, Zandile Mafe. I want to bury it more if it doesn't move to Bloemfontein or Pretoria.
Mafe was arrested after the blaze which affected both the old and National Assembly buildings of Parliament in January last year. He's been detained in the hospital section of Paulsmoor Prison following his recent evaluation, the second since his arrest. An initial evaluation found that he suffered from paranoid schizophrenia, but the court overturned the findings due to procedural technicalities. Court proceedings were peppered with outbursts from Mafe.
I want a life sentence of 25 years from now, 2023, until after 2043. I'm not afraid of a life sentence. You took me to the psychiatrist. There is no psychiatrist. It's a court, it's a private court.
His lawyers have asked for a 6-week postponement for their own forensic psychiatrist to assess Mafe and the report findings.
It was extremely difficult to get experts to help us. And obvious, the court reiterated it on a number of occasions that Mr. Mafe has got a right to challenge and interrogate the findings. So in doing so, as an attorney, we don't have any expertise. We only defer that to the experts, relevant experts. So it was extremely difficult to get experts willing to help Mr. Mafe. Most of them would say, we are not available. Some of them would say, okay, we can be available provided you bring Mr. Mafe in our practices.
Judge Erasmus has lambasted the defence for the numerous delays and lack of communication from them after the report and its findings were made available to them. He would only grant a 3.5-week postponement and warned that this would be the court's final indulgence.
I will, however, not disclose the diagnosis, which is his medical condition, but I will disclose the findings that they were required to report on. So I will read into the record the findings. The findings were, 1, that the accused is unable to follow court proceedings as to make a proper defense. Secondly, that at the time of the alleged offense, the accused was unable to appreciate the wrongfulness of the act in question and unable to act in accordance with such appreciation of wrongfulness. These findings were made as a result of a diagnosis of a mental illness.
The state says if the diagnosis, as it is contained in the psychiatric report, is correct, it is concerned that the delays are unfair to Mafe.
It's not in the interest of justice for us to keep him this long, and that we need to have a movement in this case. Yes, there was a situation or an instruction that was given at the lower courts, which was overturned due to a technicality in this court. We've always wanted to have him observed. As you know, we've tried several times. He was observed, was sent for observation, and the results came back. And it's up to now to the defense to come up with this, with their own expert who will be able to advise.
The court has ordered that Mafe be detained in a hospital section of Pollsmoor or any other correctional centre which can offer him the medical care he needs. The matter is expected back in court on the 10th of August. Vanessa Puna, SABC News, Cape Town.
All right, more news on the other side of this break. Do stay with us. Welcome back. Thank you very much for staying with us. Now, government has allocated close to 25 billion rand to deal with the water crisis in Sekhukhune District Municipality in Limpopo. This announcement was made by President Cyril Ramaphosa. That's during the 8th presidential Imbizo in Burgersfort.
The Sekhukhune district, the mining hub of the Limpopo province, which has the potential of being the mining capital of the country. But residents have failed to reap the rewards. High unemployment rates, lack of access to tertiary institutions, illegal mining, crime, poor roads and water challenges are the order of the day. Despite previous water projects having been commissioned in Sekhukhune over the years, government has now promised to tackle the difficulties that continue to plague the people of this region, even if it takes the intervention of national government.
We will solve a problem ya metsi, go tlo ba le 24 billion rand e tlo solvang problem ya metsi. Ke ona tswelopele re nyakang.
Ramaphosa also sent a stern warning to municipalities who fail to deliver on services that such incompetence will no longer be tolerated. He says government, through the district development model, will be introducing a new approach to ensure the implementation of projects. It has been found that some municipalities in the province fail to spend the municipal infrastructure grants meant for service delivery amidst a vast backlog of infrastructure development and send the money back to Treasury.
We want our municipalities to function, and as they function, we want the best of the best to serve us. People who have capacity and capability.
Lack of education is also a challenge in the region, with just 4% of the residents in the district having higher education qualifications. The president has seconded a call for mining colleges and universities to be built in the region.
I want a mining academy and college here in Sekhukhune for Ibekhona. So I'm going to be making a direct call. I think it is unacceptable for in an area which has such a bright future with mining here, and mining is going to continue here in Sekhukhune, Liko Waterberg, for a very long time. We want a mining college, a mining academy, and even 2 universities.
The president also announced the improvement of the R37 road, which links the area to Mpumalanga. The 9th and last edition of the presidential Imbizo will be heading to the Eastern Cape next month. For SABC News, Natasha Piri in the Sekhukhune district, Limpopo.
COPE is no longer registered as a company with the Companies Intellectual Property Commission. It has emerged the party was registered as a company in November of 2008. These details are contained in a letter from the lawyers of one of the party leaders, Willie Madisha, to the IEC. COPE does, however, remain registered as a political party with the IEC. Now, spokesperson Dennis Blum says they've called an urgent Central National Committee meeting to discuss the latest development. Speaking to SABC News, he says this has serious implications for the party as it prepares for the 2024 elections.
I must say that I personally, and I'm sure many of the COPE members were not aware that COPE was registered as a company. This is news to me. I am shocked that COPE was in fact registered as a company by Mr. Lukota and some other people. But I can confirm, because I've seen this letter that came from Mr. Deputy President Madisha and Tate Kleko's lawyers. This is news to me. I was never aware that COPE was registered as a company. I know that COPE is a political party.
Johannesburg Water says more areas are gradually starting to receive water again as more water systems recover. Both Soweto and Lenasia systems continue showing improved supply. Now, yesterday morning, residents in Rosebank, Dunkel West, Oakdean, Kenilworth and parts of Soweto had already started getting water in their taps. Meanwhile, the Johannesburg South and CBD areas continue to show slow recovery. Joburg Water says additional water tankers have been deployed to the Johannesburg CBD areas to mitigate the slow or rather low water supply. Road freight operators from South Africa and neighboring countries are worried about the potential loss of revenue after fresh attacks against trucks. Transport stakeholders have expressed their concern at the CSIR Pretoria for the 41st Southern African Transport Conference.
Calls are mounting for more protection and intervention for road freight operators following the recent spate of trucks set alight in the country. As a precautionary measure, some operators have beefed up their own security on the road. Other businesses continue to count their losses caused by delays and interruptions following the attacks.
It looks like it's a national problem. It's not just service delivery. It's more like anarchy in some form. But I think if you look at the problem in the layers that it presents, you actually have the cause or the actual incident, but you have the driver who's there facing all of this. Now, we've had 3 drivers who were affected in the last month. 2 drivers who were affected by hijackings. One was held in the boot of the car for about 5 hours. One was held at gunpoint for about 4 hours. And then we had one who was in an incident where they burnt his truck with its cargo. So this driver was there pleading with them for 45 minutes that they do not actually harm his truck or his cargo, because that truck is his livelihood. His entire life depends on it.
The incidents have also affected operators from the neighboring countries moving freight in and out of South Africa. Mozambique's trucking company Lalgi Transport says their businesses cannot afford to carry the high costs associated with regular delays and inefficiencies at the border post, and now the violence.
This is a huge impact on our transport companies, for all transport companies. It's this touching of trucks is causing us a huge loss and the damage on our profits, our drivers, the safety of our drivers. All these issues is affecting us hectic, and is getting worse and worse day by day. That we're not feeling safe even to deliver the goods. We don't deliver in time because the roads gets blocked. Anytime the trucks get touched, lot of protesters in different areas in the corridors. We run cross border Mozambique to South Africa.
Investor confidence in the economy could take a nosedive, with the transport sector saying the attacks give brand South Africa a bad name.
If it happens once, if there's a single incident and then it gets dealt with by the police, that's one thing. But when it continues, like we've had now 3 days in a row, we don't know what's going to happen in the future. It's absolutely important that the police get onto this, that they find out who the perpetrators are, and then that would help to assist with maintaining the business confidence. But as you say, if this carries on, it will have a big impact on business, especially overseas investments.
The country's economy remains fragile, and the role players believe it should be all hands on deck to salvage the trading of goods with other nations, hoping that the impending Economic Transport Regulator Bill will bring about the much needed interventions for the industry. The truck and freight logistics industry is a sector pivotal for the country's economy, with concerns that the over 80% of goods and cargo moving from other countries to South Africa will be reduced from these incidents, and investor confidence also hampered. This is something that role players agree that the country and its people cannot afford to see happen. Hence, the voices have grown louder here for concrete interventions. Katlego Logodi, SABC News, Pretoria.
The Department of Transport says it needs at least 18 more months before it can look at implementing the Administrative Adjudication of Road Traffic Offences Act. Now, earlier this week, the Constitutional Court ruled in favour of the government's plan to introduce a demerit system for traffic offenders. The organisation Undoing Tax Abuse had challenged the AARTO Act as unconstitutional.
AARTO sought to get their Pretoria High Court victory of November 2022 confirmed by the Concourt. They wanted the court to rule that the AARTO legislation was unconstitutional and invalid.
The constitutionality might arise in other forms of how those municipalities and metros protect their own revenues from the hands of the RTIA, which is an empire-building situation of making a lot of money at a national level when those revenues should be accruing to local government.
But Chief Justice Zondo disagreed. He refused to declare the AARTO Act as unconstitutional. A disappointed AARTO says the ruling will have far-reaching consequences.
The Constitutional Court has said go ahead. Well, then go ahead and launch it, and let's see what happens. We don't want to sit here in 2 years' time and say we told you so.
While the Automobile Association has raised concerns on the impact AARTO will have on road users.
It's not going to achieve that intended outcome. You can't legislate a problem in the hope that it's going to solve that problem. You need practical solutions, you need boots on the ground, and you need a system that is going to operate efficiently. And our concern is that none of those requirements are currently present.
AARTO introduces a points demerit system for traffic violations.
you need to capacitate the system by giving traffic law enforcement the resources they need in terms of human resources. So we feel you need more than double the amount of traffic law enforcers than what you currently have. Obviously, there is an administrative requirement in terms of both human and equipment resources.
The Transport Department has given itself several months to train their staff on the system.
The next step now, it is indeed the proclamation of this particular act into law, and it has to be signed by the president into law, and then he's going to have to also give the date in terms of when it's going to come into law, and that will be gazetted as well. And thereafter, the AARTO, which is Road Traffic Infringement Agency, takes over in terms of the implementation itself.
You start on a clean slate with 0 points. Each road infringement results in a minimum of a 1-point demerit and a fine or penalty. When a maximum of 12 points is reached, your driver's license is suspended for 3 months. A license is cancelled when it's been suspended for a third time. Fines and notices will be served via email and reminders sent via WhatsApp and SMS.
The training of the back office staff who are issuing the courtesy letters and so forth, that kind of training needs to happen as part of the implementation plan. And then part of what we had said initially before we went to court, where it was found to be unconstitutional, we had said our implementation will start with about 69 municipalities where we are going to implement. And then we're going to move into about 144 of them after that. And then the demerit points comes right at the end.
In the making since 2013, AARTO has faced a slew of court challenges, with civil bodies raising concerns that the Act won't improve road safety and will simply be a costly exercise. Nozintombi Mia, SABC News.
Welcome back. Thank you very much for staying with us. Now, South Africa's double Olympic 800 meters gold medalist, Caster Semenya, has won a crucial legal battle in her fight to compete without taking drugs to lower her testosterone levels. But the victory does not question the World Athletics ruling nor allow her to compete in the 800 meters. The European Court of Human Rights has ruled that courts in Switzerland should allow her to fight the requirement. 32-year-old Semenya had approached the court in February of 2021 after losing appeals at the Court of Arbitration for Sports as well as the Swiss Federal Tribunal. The ECHR ruled that Semenya's original appeal against World Athletics regulations had not been properly heard, and she had not been afforded sufficient institutional and procedural safeguards in Switzerland to allow her complaints to be effectively examined. The Department of Sports has welcomed the ruling, saying although the battle is far from over, it will continue to support Semenya and Athletics South Africa in their fight for the dignity of women athletes. All right, now joining us for more on this is Lita Ngubo. He's the spokesperson of the Department of Sports, Arts and Culture. Lita, good afternoon. Thank you very much for your time. Now, this judgment has been hailed as a victory for human rights, but many were quick to stress that it is of no consequence on the track immediately. Just your views on everything and how everybody's been unpacking this ruling.
So thank you for the invite to the show. It's been a long fight for Caster since 2018, and the Department of Sport, Arts and Culture has been with her throughout that fight. So for the European Court of Human Rights to make the ruling that it did this week, it was a relief as it justified and it vindicated Caster's fight for dignity. And it emphasized the call just for women's sports and the rights of women to be respected in sport. Because watching from Caster's experiences as a professional athlete throughout her career, she's been exposed to offensive treatment pertaining to her being.
Mm-hmm. But then how long before this type of a ruling is infused into regulations going forward? Because that has now, post everybody being so excited, that is what now the debate is about, that how long would it take? Would it even allow for Caster to still be of an age to still compete?
So that is what the concern is now, because despite the ruling saying that Caster's dignity was infringed in her fight, it doesn't necessarily compel World Athletics to change their regulations. And as you saw World Athletics with their statement, they maintained their position and said they would be studying the judgment. So it's still a concern that there is still no movement from their side to try and address what is clearly an offensive regulation to women athletes with differences in sexual development.
But I suppose this is a very significant start. I'm sure you've been in communication with Caster. How is she feeling, or what was the first thing she said to you guys post to that judgment?
Well, I can't say specifically what Caster said, but what I can state is that Caster is clearly very happy about this ruling. But also it's not significant for Caster as well, because you might know that these regulations affected several other athletes from the continent. And the latest of which, of course, was Christine Boma in Namibia, who won an Olympic medal at the previous Olympic Games. Caster is not just for her. Caster represents all the women from around the world who've been offended by these regulations, which limit them from performing in their chosen disciplines in athletics. So this is significant not just for Caster, but for all women athletes around the world.
And possibly indicative of her generosity or her generous spirit to pay it forward, to say, I might not benefit in the present future, but most certainly it will be a conversation for athletes to come. Unfortunately, our line is a bit terrible there, but thank you very much for joining us today, Lita. That's Lita Ngubo. He's the spokesperson for the Department of Sports, Arts and Culture. Let's take a look at this story now. As South Africa experienced a nationwide cold front, many Gauteng residents woke up to fluffy snowfalls on Monday morning. It's the first snow in Johannesburg since 2012 and was a delight to many.
Light snow pattered down across large parts of Johannesburg. This includes suburbs such as Auckland Park, Randburg, Roodepoort and Alberton. Snow also fell in both the eastern and western parts of the province. One Wits University biometeorologist says it was just below 2 degrees when the snow began to fall.
So it's often a misconception that you need to drop below zero to have snow. It was about -1 this morning driving in. It's a bit warmer now, and you actually need slightly warmer weather for that snow to form. And often in the UK you'd see it snowing at around 4 degrees.
One small business owner inside a taxi rank did a bristling trade in hot beverages.
The cold has helped me with sales. We always bake, but today we had to bake more than we would normally to meet the demand.
Social media has been a buzz, with residents posting pictures and videos of the snow. Mbalenhle Mthethwa, SABC News, Johannesburg.
All right, more news on the other side of this break. Do stay with us. Welcome back. Let's move further afield. Independent Zimbabwe presidential candidate Xavier Kusuwere has accused the president Emmerson Mnangagwa of using the courts to fight political battles. Now, earlier this week, the Zimbabwe High Court barred Kusuwere from contesting the presidential election in August on the grounds that he had been out of the country for more than 18 months. He has appealed the ruling, and the Supreme Court of Appeal has set aside the High Court's decision until the matter is finalized.
And wants to know.
Xavier Kusuwere is confident that his name will be on the ballot paper on the 23rd of August. He says these are tactics to derail his campaign for elections and to disqualify him by the incumbent President Emmerson Mnangagwa. He says the High Court erred in its conclusion.
Our papers were accepted a day or so ago, and we are waiting obviously for the registrar of the Supreme Court to contact our legal team in Harare, and upon which I think they will then spell out the processes and steps to be taken thereafter. With regards to the prospects of success, we are 199% certain that our appeal before a competent bench of lawyers or judges, we will succeed.
He has lambasted the incumbent President Mnangagwa and accused him of using state resources and courts to fight political battles.
This comrade has always wanted power through hook or crook. And we are not surprised with what he has been doing. As you know, that he had to roll guns out, tankers, to dethrone Robert Mugabe. That was a coup, whether people like it or not. That was a coup. And he misled a lot of people in the process.
Kasikuwere says trumped-up charges have been instituted with the aim of harassing him.
And he will not stop at harassing some people like myself. Spurious charges. He has gone to court on several occasions. As I'm speaking now, he's busy trying to cook up some evidence. Let's look for something to do with Kasikuwere. Once he lands, we must jail him for 3, 4, 5 years. He even interfered in my own trial to the extent that my lawyer, then Jonathan Samkange, was removed. He called him to his office and said, Wena, if you stand and defend this one, we want to send Kasikuwere to jail.
Regional blocs and mother body such as SADC and AU will be put to test during the upcoming elections in Zimbabwe. Opposition parties have been complaining about being barred from holding their election campaigns.
We are aware that SADC is looking forward to these elections, and I call upon SADC leadership to take note. Please take note. We need Zimbabwe out of this ditch. This is a huge test on our SADC leadership. It is a huge test on the IU as well as observers, that Zimbabwe should be able to produce a set of results out of an election that is little disputes, very little disputes.
Kasikuwere further says millions of Zimbabweans will be disappointed if it doesn't contest in these elections. He says people of the neighboring country need change now. President Mnangagwa has also signed into law the Patriotic Act, which contains a clause that criminalizes willfully damaging the sovereignty and national interest of Zimbabwe. Khalihle Khumalo, SABC News, Johannesburg.
As part of the celebration of King Letsie III's birthday on the 17th of July, the Central Bank of Lesotho has printed the first of a historic 200 Maluti note to mark his 60th. 5 million of the 200 Maluti will start circulating as soon as the commercial banks complete the collaboration process to authenticate the new notes.
His Majesty King Letsie III is turning 60 on July 17th, and the Central Bank of Lesotho will for the first time be launching an iconic 200 Maluti to commemorate the Diamond Jubilee for the King.
Ladies and gentlemen, I am delighted today to inform you that for the first time in the history of nearly 45 years of the Central Bank of Lesotho, we are launching a commemorative banknote for the King of Lesotho. We have printed 5 million pieces of these notes. Unlike in the past, these notes are intended for general circulation and to facilitate the celebrations with the King by every single Lesotho.
And the former central bank governor and now the Minister of Finance says this is a welcome development.
There's an important feature that I like that you didn't change. That the founder of this nation is still in here. It marks a new era for us, for him, for his family, and for Lesotho.
It will, however, take some time for Basotho to start seeing the new note in circulation.
After the 17th, we are now going to draw a plan with the commercial banks. I think the maximum that they will take to calibrate their machines will be a period of 6 months at the most.
This new note will be carrying a green banknote due to the nature of a substrate that has been used, which greatly reduces the plastic hazard material often present in many banknotes. Rabelang Khatebe, SABC News, Masero Lesotho.
And that's where I leave it for today. Have a wonderful afternoon further. Goodbye.